Okay, Mr. Grant, did you have a chance to meet with your lawyers to discuss this particular issue?
I did.
Okay, and do you feel that you have had your concerns answered or your questions answered?
Yes, I have had those answered.
Okay. Just to return to that question then, do you understand that the scope of the court's discretion with regard to sentencing at this time?
I do believe I understand that discretion.
On page 7, there are 2 paragraphs that are crossed out. Do you understand that they're crossing out and the initials next to those paragraphs indicate that those do not apply to you?
That's correct.
Okay. Do you understand that burglary in the 1st degree and rape in the 3rd degree are most serious offenses as defined by RCW 994A-030, and that if you have at least 2 prior convictions on separate occasions of most serious crimes, you may be found to be a persistent offender. If you are found to be a persistent offender, the court may impose a mandatory sentence of life imprisonment without the possibility of early release. In layman's terms, this is, do you understand that burglary in the 1st degree and rape in the 3rd degree are strike offenses for purposes of the state's 3-strike law?
I do understand that.
Do you understand that count 3 includes a deadly weapon enhancement of 6 months? This additional confinement is mandatory and must be served consecutively to any other sentence and any other enhancement I have already received, or you have already received. Do you understand that?
I do.
Okay. On page 9, there are more paragraphs that are crossed out and initialed. Do you understand that those do not apply to you?
Yes, I do.
As well as on page 10, another paragraph that is crossed out. Do you understand that that does not apply to you?
I do understand that.
Do you understand that if, as a result of pleading guilty, you would be required to undergo testing for HIV?
I do understand.
Do you understand that if you are not a citizen of the United States, a plea of guilty may have consequences to your immigration or naturalization status?
Yes.
Do you understand that you will be required to provide a biological sample for purposes of DNA identification analysis?
Yes.
Do you understand that you will be required to register where you reside, attend school, or work, and that the specific registration requirements are outlined in Appendix J, which I referenced earlier?
Yes.
Okay. Have you had a chance to review that form?
I have.
Do you understand that as a result of pleading guilty, you'd lose your right to possess, own, or have in your control any firearm unless that right is restored?
Yes.
You also understand that you would be ineligible to vote until that right is restored in a manner provided by law?
Yes.
On page 12, there are additional paragraphs that are crossed out and initialed. Once again, do you understand that those do not apply to you?
Yes.
I'm going to turn to page 14. There is a handwritten statement which indicates see attached statement incorporated herein by reference. And with that, I want to turn to an addendum to paragraph 11 entitled Defendant's Statement for paragraph 11. Statement to addendum to statement of defendant on plea of guilty. And I'm going to read this in sections and then ask you some questions about it, okay?
Okay.
On or about August 19th, 2012, in King County, Washington, I entered and remained unlawfully in a building located at 820 North 145th Street, Shoreline, with the intent to commit a crime against a person or property therein. In entering and while in such building, I assaulted Y.C., date of birth 7/31/59, by having sexual intercourse with her without her consent, count 1. That same day in King County, Washington, on or about August 19th, 2012, I engaged in sexual intercourse with Y.C., date of birth 7/31/59, who was not married to and not in a state-registered domestic partnership with me under circumstances where Y.C., date of birth 7/31/59, told me she did not consent to sexual intercourse with me, and such lack of consent was clearly expressed by YC's words or conduct when she told me she did not want to have sex with me. Count 2. I'm going to stop there for just a moment. Do you have any questions or additional consultation you need with regard to those first 2 paragraphs?
I do not.
Okay. On or about August 28, 2012, in King County, Washington, I engaged in sexual intercourse with CZ, date of birth 7/7/67, who was not married to and not in a state-registered domestic partnership with me. Under circumstances where CZ, date of birth 7/7/67, did not consent to sexual intercourse with me, and such lack of consent was clearly expressed by CZ's words or conduct when she told me she did not want to have sex with me. Count 3. During a period of time intervening between July 15, 2012 through July 25, 2012 in King County, Washington, I attempted to engage in sexual intercourse with FW, date of birth 5/13/74. I have reviewed the original and amended charges, police reports, and the anticipated evidence against me with my attorney. I am pleading guilty to the amended charge of rape in the 3rd degree in order to take advantage of the offer by the prosecution. I acknowledge there is not a factual basis for this amended charge, but I agree there exists a factual basis for the original charges of attempted rape in the 2nd degree as set forth in the certification for determination of probable cause. I believe that if this matter proceeded to trial, there is a substantial likelihood I would be found guilty of the original charge. This all happened in King County, Washington. I agree the court may review the certification referred to above in order to make a factual determination and for sentencing. On or about September 24th, 2012, in King County, Washington, I did engage in sexual intercourse with JW, date of birth 8/24/67, who was not married to and not in a state-registered domestic partnership with me, under circumstances where JW did not consent to the sexual intercourse with me, and such lack of consent was clearly expressed by JW's words or conduct when she told me she did not want to have sex with me. Count 5. During a period of time intervening between June 15, 2012 through July 20th, 2012 in King County, Washington, I engaged in sexual intercourse with another person named MZ, date of birth 10/30/92, who was not married to and not in a state-registered domestic partnership with me, under circumstances where MZ did not consent to sexual intercourse with me, and such lack of consent was clearly expressed by MZ's words or conduct when she told me she did not want to have sex with me. Count 6. Mr. Grant, I know from personal knowledge that you did not actually write these statements, but are you prepared to adopt these statements that I have just read as the defendant's statement for paragraph 11 for purposes of this plea?
Yes.
I want to just spend a moment on count 4, and this is this language indicates under State v. Zhao or In re Bar an opportunity to take advantage of the offer by the prosecution, even though there is not a factual basis for this charge. Do you understand that terminology that I read?
I do.
Okay, and have you talked with your attorneys about what that means for purposes of this plea?
Yes.
And are you prepared to allow the court to review the certification to make factual findings for the original charge?
Can I have?
Yes.
It's the last part of the last several words you mentioned.
Okay, let me read.
The court needs to find a factual basis for each of the charges. Somebody can't simply be brought in off the street and because they want to get out of the cold, plead guilty to something that they didn't do. So the factual basis needs to come either from the admission or from the stipulation that the court can consider the statements that have been provided. As I understand your position or the party's positions with respect to count 4, it would be this. It's your position that you either don't recall or the act of sexual intercourse was not completed on that day. You're in agreement that the facts as stated would be sufficient to constitute the crime of attempted rape in the 2nd degree, which is equal to or perhaps more serious than rape in the 3rd degree. But the agreement is to enter the plea of guilty to the charge of rape in the 3rd degree, which requires as an element the completed act of intercourse. because it is part of the agreement of the parties, and it seems to be advantageous to all to handle it in that fashion. Is that a fair summary?
Yes, I understand.
Okay. And then with regard to counts 1, 2, 3, 5, and 6, I asked you if you were adopting those as well for purposes of this plea. And my next question is, are those true statements about what happened on the dates that I read for each of those counts?
I adopt those.
On page 2 of this statements, defendant's statement for paragraph 11, there's a signature above the words Danford Grant. Is that your signature?
Yes, it is.
And did you sign this after consulting with your attorneys and discussing this item?
Yes.
I also want to take a moment, Mr. Grant, and discuss the felony plea agreement as well as the addendum to the plea agreement. Felony plea agreement is a form that I asked you about earlier, and you had indicated that you had reviewed with your attorneys. The felony plea agreement outlines that counts 6, 7, and 9 of the second amended information were previously dismissed, and that you agree with the state that these counts may be refiled and waive any objection to refiling of these counts as pursuant to the plea agreement. And they are refiled as a different charge, obviously, and I want to make sure that that is something you are agreeing to and understand.
Yes.
Okay. Additionally, there is an agreed sentence that you, as part of this plea agreement, agree that all terms are agreed, and that count 1 does not merge with count 2 and does not constitute the same criminal conduct. Do you agree with that provision?
Yes.
Additionally, that you agree and incorporate, and the parties incorporate herein the addendum agreeing to the consecutive exceptional sentences on counts 2 through 6 for a total term of 25 years. Do you agree with that provision?
Yes.
And to that end, there's a document here entitled Addendum to Plea Agreement, which contains 4 paragraphs outlining agreements pursuant to this plea agreement and stipulations to the following facts: that the parties agree for an exceptional sentence of 60 months confinement on counts 2, 60 months confinement each on counts 2, 3, 4, 5, and 6 to run consecutively for a total of 300 months confinement. The parties also agree any confinement imposed under count 1 would run concurrently to counts 2 through 6. And there, in counts 2 through 3, there is an agreement regarding certain facts that support the exceptional sentence, including that under the charges of the 4th amended information, the sentence of the standard range would be too lenient in light of the purposes of the Sentencing Reform Act, and as such, the parties agree to the exceptional sentence. Have you reviewed each of these terms in the addendum to plea agreement?
Yes, I have.
And do you agree with each of those terms as part of this plea agreement?
Yes, I do.
On the felony plea agreement, there's a signature above the word defendant. Is that your signature?
Yes, it is.
And on the addendum to plea agreement, there's a signature above the word defendant. Is that your signature as well?
Yes, it is.
And did you sign those after consultation with your lawyers regarding this plea?
I did.
Mr. Grant, other than obviously the threat of going to trial on charges that may involve increased confinement or different types of confinement, has anybody made any threats of any harm of any kind to get you to plead guilty today?
No.
Other than the information contained in these forms that we have reviewed this morning, has anybody made any promises of any kind to get you to plead guilty today?
And one moment, please.
Yes.
I'm sorry, could you repeat your question?
My question was, other than the information contained in these forms that we have just reviewed, has anybody made any promises of any kind to you to get you to plead guilty today?
No.
I'm just going to observe that it's kind of like entering into a written contract, a fully integrated contract. Are there any oral promises or representations that haven't been reduced to writing and made a part of this agreement that's being memorialized and will henceforth be binding?
Right.
That's the question.
On the last page of this statement of defendant on plea of guilty, there's a signature above the word defendant. Is that your signature?
Yes.
Then, Mr. Grant, with regard to the fourth amended information, count 1, burglary in the first degree, how do you plead, guilty or not guilty?
Guilty.
With regard to count 2, rape in the third degree, how do you plead, guilty or not guilty?
Guilty.
With regard to count 3, how do you plead, guilty or not guilty?
Guilty.
With regard to count 4, how do you plead, guilty or not guilty?
Guilty.
And with regard to count 5, how do you plead, guilty or not guilty?
Guilty.
And with regard to count 6, how do you plead, guilty or not guilty?
Guilty.
Your Honor, the state believes that there is a sufficient factual basis both in the addendum to paragraph 11 as well as in the certification for determination of probable cause to support each of the 6 counts. We believe the defendant is entering this plea knowingly, intelligently, and voluntarily based on the colloquy and based on representations of counsel and observed discussions between Mr. Grant and his attorneys, and we'd ask the court to accept the plea on all counts. I'm handing forward the paperwork at this time.
Has all the paperwork been signed?
I believe so. If not, we will certainly remedy that problem.
Make sure I've not had a chance to take a look at it yet, although I am familiar with it, certainly. Mr. Hoffmecker, Mr. Hanson, are you comfortable with the time that you've had and the ability that you've had to discuss with Mr. Grant his options?
We are, Your Honor. Yes, sir.
All right. Again, I saw all of you out in the hallway late yesterday afternoon after we had long been in recess for the day, and there was obviously deep concern on everyone's faces, and you were working through, I presume, all of these options. And are you comfortable proceeding on the agreed basis?
Yes, Your Honor. Yes, sir.
All right. Mr. Grant, you agree with that?
Yes.
I summarized before the things that I need to find. I think you understand my job fairly well. I need to be sure that you understand the nature of what you're doing, all those rights that are being given up, that you understand the consequences that flow from it. I think the prosecutor covered everything except possible revocation of a commercial driver's license, but everything else is in there. Most importantly, the sentencing options that are applicable in the case. I need to find that that there's a factual basis. We discussed that in connection with the paragraph 11 discussion. I need to find that it's a voluntary decision on your part, free from any threats or promises. And then finally, I need to find that the plea agreement is consistent with the interests of justice. Any of those 5 things that you think ought to cause me a problem?
No.
Okay. As far as the nature of things, mostly it's the rights to go to trial and dispute the truth of the allegations. We'd spent a couple of days choosing a really, I think, excellent jury to decide this case. You understand the rights that you would have, both from your legal training, your discussions with counsel, as well as the review of the form that we've just gone through, all of the rights that you would have at trial if you wish to proceed down that path.
I do understand those rights.
Any question about any of that?
No.
But pleading guilty, a case goes straight to a sentencing hearing. And the right to appeal any question of the adjudication of guilt is waived. That's all gone at that point. There still may remain some limited appeal rights relative to the sentencing, although those are fairly narrowly circumscribed based on the agreed positions of the parties, but all those rights to dispute the truth of the allegations at trial or to appeal from the guilt determination, those are all waived.
I understand that.
Understood. Okay. All right. The consequences have been gone over pretty much in detail. I don't intend to reiterate all of those. But is there any aspect of the sentencing options in particular that causes you any concern, any question, any hesitancy at this point? If so, let me know, or you can take more time to talk to your counsel about it.
Only the concern I mentioned before, which I think has been resolved.
And which did that relate to?
Your Honor's discretion.
Yeah. Okay. Right. Yeah, it's as I phrased it a moment ago, the court's discretion is somewhat circumscribed by the agreements of the parties at this point. And well, let me rephrase that. My discretion may not be circumscribed by it, but your right to appeal from a deviation is circumscribed by the agreed positions of the parties, I guess. At this point. Okay. Let's see. As far as the factual basis is concerned, I'm not going to make you repeat what was stated in paragraph 11 or the additional aspects relative to paragraph 4, but do you have any hesitation in adopting those statements? I think that was the phrase you used. Mr. Ritchie asked, do you adopt this statement at this time? And you said, I adopt this statement.
I do.
Okay, all right. And you understand that the court will act upon that at sentencing, treating those as truthful statements, that on the dates in question you engaged in sexual intercourse without the consent of the victims, for instance, on each of counts 2 through 6, and that on count 1 you entered or remained unlawfully with the intent to commit a crime against a person in that particular home.
I do understand the court will do that.
All right. As far as voluntariness is concerned, I analogize it to a contract, since I figure those are terms that you can well identify with. Is there anything else that you have as an expectation at this point, based on anything that's been communicated to you about what likely lies ahead for you? Anything else that ought to be memorialized this time?
My expectations are based on what the law requires with regard to certain sentencing issues and things like that. So I don't think that's technically an agreement. It's I have an understanding of what lies ahead in terms of good time and things like that, based on what the law is regarding sentencing.
Okay. All right. Good. The final determination the court needs to make is that the plea agreement is consistent with the interests of justice. Is there any comment that you'd like to make with respect to that?
Not for purposes of the plea. I anticipate I'll be making a statement at sentencing.
Yes, and I was not intending to preempt that at all. I just wanted to give an opportunity. If there's any statement you wish to make, there obviously will be public concerns, whether this was a plea agreement that involved concessions made to you, or on the other hand, an acceptance of responsibility by you. And that's why I wanted to give an opportunity if there's anything you wish to say in connection with the interests of justice.
Not at this time.
Okay. All right. Let me take a look through the paperwork here and make sure it is all consistent with my understanding and the discussions that have gone on.
Your Honor, there's a small question that I think we should address before the court actually makes final findings. The parties had this conversation about credit for time served, and it is a component of the plea agreement that the defendant would get credit for the time he has served. And the basis for that is because we believe the case law mandates that.
That was my inquiry.
Yes.
Whether it's discretionary.
We
I thought
researched
that
this
as well.
extensively,
Yeah.
and it is part of the findings.
Yes.
And we came to agreement on the
Right.
law.
That was my understanding as
Right.
well. I wanted to make sure that was
I
consistent.
think there was a question of whether or not that had been captured in one of the forms, and we wanted to make that explicit in the event that it was not.
And
I think it's an answer to your question. Has
Yeah.
anybody else made any other promises that
Right.
aren't in the documents that are necessarily in front of you right now? And the answer to that is yes, in that regard.
Okay, very good, very good. And I appreciate putting that on the record. Anything else that you can think of? Are there any questions or any hesitancy that you have at this point?
No.
Okay. Are you prepared to have the court accept the plea of guilty to counts 1 through 6 in the Fourth Amended information, understanding that once I've placed my signature on these pages, there's no reversing course?
Yes.
Okay, all right. Do you plead guilty to counts 1 through 6?
Yes, I do.
Okay. I'll go ahead and sign the form. I believe Mr. Grant does have an adequate understanding of the nature and consequences of what he's doing. I think it's a voluntary decision on his part, supported by an adequate factual basis, and the plea agreement is consistent with the interests of justice. I'll sign the plea form, first of all, the plea agreement form as well. And I've signed the order permitting the filing of the amended information. The bailiff has proposed a date of Monday, May 19th at 9 o'clock for imposition of sentence. And I don't know if she cleared that with you, but if it's
Yes, Your Honor.
agreeable, that's when we'll plan to reconvene.
And did the court also sign the stipulated findings of fact and conclusions?
Those are.
those are for
I thought that was a sentencing document to be entered
It
at that
is.
time.
Right. There is an addendum to the plea agreement, but it does not include the
Right.
conclusions of law until the time of sentencing.
Okay.
Right, it's simply a stipulation knowingly and voluntarily entered into by all the parties.
It says the date on the top.
If we have no further business, let me explain what I intend to do next. We've got the 14 jurors assembled across the hallway. I intend to bring them in, and I will speak with them, explaining to them what has occurred, thanking them very sincerely for their services. You do not need to be here for that, and I can well understand why you would prefer not to be. Anyone that wishes to stay is certainly welcome to. We'll be doing it in open court, and with the jurors occupying their assigned seats in the jury box. So the option is yours. Again, I understand that you may well choose to depart.
Your Honor, there is one other thing that we need to accomplish. The
Yes.
pleas today of burglary in the first degree and rape in the third degree are not auto remand crimes, and therefore the parties have also reached an agreement regarding the conditions of release pending sentencing on the 19th. And I've prepared an order indicating that the defendant is to maintain his appearance bonds set at the time of his release in 2012, and to maintain the same schedule and rules set forth by current conditions of electronic home monitoring through the engagement of a private home monitoring company, such monitoring to be implemented by May 9th, which is this coming Friday. So,
You understand that?
So does that mean that I will now be switched from EHD to a private company?
That's my understanding.
yes, because of the plea to a sex offense, the county's EHD program will not monitor, so you will have to obtain private company to do that.
And do you have all the information that you need to effectuate that?
We will get it. And I'm going to ask if they can make an exception. If not, we'll contract with a private company.
Well, EHD may be bound by law and have no
That could
options.
well be.
Yeah. Okay. All right. Well, that was my understanding, that the conditions would remain as close to the same as they have been for the next couple of weeks.
We have no objection to that.
All right. Okay, I'll pass down that order as well as all of the other favors. Anything else that we need to discuss on the record today?
No, Your Honor.
Okay, Mr. Grant, anything else?
No,
All right, I'll see you in a couple weeks then. No, okay. They don't deserve it. Yeah, sure. Is that your first time on jury duty?
No, it's not actually.
Yeah, good. Those are good seats.
They're great.
Comfortable, a good view of the action.
Very nice.
Now let's begin. Okay, thanks.
Oh, all right.